Hi everybody, today we're going to talk about the semi-presidential and parliamentary systems in Armenia. In August of 1990, debates on adopting a new political system became dominant in Armenia. In the summer of 1991, two fronts existed in the political field. On the one side were those stressing the necessity of adopting parliamentary form of government, while on the other side were those supporting the presidential way of government. The arguments put forward by the supporters of the presidential form of government were found more reliable, and since then, the semi-presidential system of government got to be developed in Armenia. According to the Legislative Act adopted from August to November of 1991, the President of the state should be elected in state elections through majoritarian electoral system for a 5-year period with the possibility of being re-elected. The President was considered to be the head of the state and the executive body. The Prime Minister was appointed by the President. Ministers were also appointed by the President on the recommendation of the Prime Minister. With the formation of the new political system, considerable changes occurred in the process of passing laws. According to the changes, laws in the Parliament could be passed only upon gaining the approval of deputy majority. That is, 2/3 of the vote was needed. Thus, the political system adopted in Armenia in the course of 1991 can be seen as a typical semi-presidential form of government. After passing laws defining the scope of activities of the President and the Parliament, necessity arose to develop a constitution in accordance with the current political situation. In 1994, the constitutional package was sent to the Parliament by the Constitutional Committee, and on March 27 of 1995, with the 2/3 of the votes, the Parliament passed the constitutional law, and on July 5 of the same year, the version offered by the committee was put on national referendum. Despite the claims on the side of the opposition members that the referendum was carried out in complete fraud, it was declared free, fair, and transparent. So Armenia adopted its first constitution. Despite the fact that the Constitution of 1995 adopted the principle of separation of branches of power, it entitles the President with pronounced domination in the field. The Constitution did not restrict the formal or informal redistribution of the powers in the field. This fact made solid basis for the power shift at the end of 1997 and at the beginning of 1998. Taking the post of the President, Robert Kocharyan formed the Constitutional Committee, which mainly consisted of lawyers and experts of constitutional rights. In 2001, the Constitutional Amendments Package was sent to the Venice Commission. The amendments package assumed guarantees for the checks and balances between separate branches of power, widening the scope of authorities entitled to the post of the Prime Minister, as well as putting more emphasis on the role of the Parliament. Thus, unlike the previous constitution, the new one, both constitutionally and legally, enshrines the parliamentary majority's right to form the government. In 2003, the proposed amendments were put to referendum, but failed because of not getting enough votes. However, on November 25 of 2005, the referendum on constitutional amendments passed. According to the amendments, the Parliament got an opportunity to have a major role in forming a government.
However, the constitutional amendment of 2005 failed to guarantee the clear distinction of peculiarities relating to the limitation of fundamental rights and their compliance with international standards. A number of articles in the list of fundamental rights provide for both general and special limitations, giving rise to differing interpretations with regard to their scope and content. Another problematic issue is that possibilities of limitations of certain fundamental rights have not been defined, whereas the necessity thereof is obvious. Despite the availability of constitutional provision as of which the limitations of fundamental human and citizen rights and freedoms may not exceed the scope laid down under the international commitments of the Republic of Armenia, the constitution in force has failed to sufficiently clarify the requirements to the limitation of rights, which is considered as problematic from the point of implementation and protection of fundamental rights, is to establish effective mechanism of real appreciation of human rights and freedoms as an ultimate value, limitation of government powers, real separation of powers, and working system of checks and balances. There are some main principles that underlie the constitutional reforms. First, clarification of rights, freedoms, and duties in terms of their content, structure, and editing. Second, ensuring the integral entirety of the scope, content, interrelation, form of setting forth and approach to the general and specific limitations. Third, clarification of the limitations of rights and freedoms based on the international standards for the classification thereof, taking into account, in particular, A, the necessity for ensuring the guarantee of inviolability of the essence of rights in order to prevent them from being blocked, B, the necessity for clearly ensuring the principle of proportionality, C, the permissibility of limiting a right only in compliance with the law, and the principle of legal certainty. National Assembly should control the executive branch and is in charge of controlling the budget and is responsible for other functions assigned by the law. Armenian National Assembly shall consist of at least 101 deputies. By the electoral law, it will allocate seats for ethnic minorities. National Assembly is elected by the proportional electoral system. The most outlandish provision of the suggested new constitution is the one providing for a second round of parliamentary elections to be held in case the voting fails to produce a clear majority for a political party. Only two parties which would receive the most votes in the first round would then take part in the runoff, and the one to win a simple majority would form the government.
The head of the country and embodies the country's unity, is elected for a term of 7-year term of office. The same person may not be elected for the post of the President of the Republic for more than one consecutive term. The President is elected by College of Electors, can be impeached for state treason, for committing a heavy crime, as well as for breaking the laws set up by the Constitution. Like in current constitution, in the draft of new constitution it is stated that prosecutor's office is an integrated system, which head is the prosecutor general. The main difference is the way he/she is appointed. By current constitution, the prosecutor general shall be appointed by the National Assembly upon the recommendation of the President of the Republic for a 6-year term. By the suggested reforms, Prosecutor General will be appointed by the National Assembly by the 3/5 of majoritarian votes for a 6-year term. By both constitutions, the same person may not be appointed Prosecutor General for more than 2 consecutive terms. The way of impeachment of General Attorney has changed as well. According to current constitution, Prosecutor General can be impeached in the cases set by law by the suggestion of President and if majority of votes is reached in National Assembly. By the reforms, National Assembly has the power to impeach the Prosecutor General if the 3/5 of votes of ministers is reached.
Prime Minister. Orders and decrees of the President require the co-signature of the Prime Minister and the Prime Minister who made a proposal, with the exception of the cases in which exercise of the President's power does not require an initiative by other state bodies. An important change of the Armenian constitutional system regards the relations between the executive and the armed force, which shall be subordinated to the government under the direct command by the Minister of Defense within the general guidelines defined by the Security Council, led by the Prime Minister. This solution gives new emphasis to the general role of the Prime Minister, while it reduces the position and the power of the President of the Republic.
We did a survey among 170 American university students, and we asked 3 questions. The first one was if they ever heard about constitutional reforms, and what was surprising was that 90% of participants said yes, and we draw a conclusion that students are somehow engaged in political life. Second question was, are you in favor of the reforms or not? And 70% of participants said no. Third question was, are you going to take part in referendum if you are 18 or more? And what was surprising was that only 80% said yes, which we draw a conclusion that if people have opinion, but they don't.
The lingering question in almost all the talks is whether the president will step down or not after the term. The history shows that after all constitutional reforms, the vast majority of parliament members were from the same party, and have had dominant position both in legislative and executive branches, and there is a small possibility that after this reform obvious changes will be observed. The real problems therefore may begin after the constitutional reform is passed. It is true that if the constitutional reform is enacted, the ruling party will receive a virtual guarantee of electoral success. The new constitution will make the task of displacing the incumbent government highly complicated, if not impossible. On the other hand, there is a possibility that the outcome of the referendum may completely shift the distribution of power. The president will have less power than now. The power will be in hand of leading party. Actually, it doesn't make any difference in this concept. It's just like the situation with UK Queen. Queen rules but never governs. This parallel drawn between these two powers may seem too critical, but it gives a somewhat clear picture of what will happen with our president. Due to our research and conducted survey, we came up to the idea that constitutional reforms have political aims, which are camouflaged under laws of human rights protection and their enhancement. Those reforms are not solutions to real life problems and will not give us the tangible results that Armenia strives for.